Hi, I'm Richard Irving. I'm a patent attorney. My focus is on drafting patent applications and prosecuting them before the U.S. Patent and Trademark Office. My particular focus is on software-related inventions, and I'm a former software engineer. It's harder to get a patent on a business process than it used to be. All patent applications in order to obtain a patent, they have to satisfy certain requirements. And one requirement is it has to fall into one of four categories, and that would be a machine, a process, a manufacture of some type, or a composition of matter, which would be like drugs, for example. If it doesn't fall into any of those categories, it's not patentable subject matter. Even if it does fall into one of those categories, it should not fall into one of the judicial exceptions. And in my particular practice, the judicial exception that I'm concerned with is abstract ideas, because I've seen many patent applications related to software that have been rejected as ineligible patent subject matter because they were allegedly directed to abstract ideas. And an example of some abstract ideas would be, for example, creating a contractual relationship, anything related to the performance of a financial transaction. There's even something called, which the Patent Office refers to, an idea of itself, which is a little hard to define, but it's something that can be, for example, something that can be performed by a human mentally, and maybe you're just doing it on a computer. It's not enough. And mathematical relationships, unless it's something more. So the way the Patent Office looks at that, they check, does it fall into one of the four categories? If not, you forget about it. If it does, is it directed to an abstract idea? And they'll look at things like I just mentioned. If it is related to it, if it's not related to an abstract idea, you're all set. If it is related to an abstract idea, then they look to see, is there significantly more in here? Is there some aspect in the claim, in the patent claim, that is significantly more than an abstract idea? And some of the things they look at would be, does this improve, for example, computer technology in some way? Or does this improve some other technology? They're also supposed to look at the claim elements in combination, not isolated from each other, because many times you can look at a patent claim and look at each element separately and say, oh, well, this is well known. But you're supposed to look at the combination. If you do these sequence of steps, there's something new and non-obvious here. Those are things that businesses have to keep in mind when they're thinking about patenting something. But even with that, there's still quite a few things that are patentable, like things dealing with artificial intelligence, satellite communications. There's all kinds of things. They could do searches. For example, they could go to the Patent Office and use the Patent Office's database, or they could do it from home on their computer, log into uspto.gov, which is the Patent Office website. You can search patents and published patent applications. Type in keywords, and keep in mind when you're looking at what pops up, if you don't find something that's identical to your idea, look at combinations of things and see if somebody in your field would be motivated to combine different things to come up with the invention. Another thing that they should keep in mind is to see if there's something there that claims something that is their invention, such that they have to worry about infringement if they go ahead and produce whatever it is that they have in mind. There are other databases too that one could look at. You could go to WIPO, which is World Intellectual Property Organization, so WIPO.org. You can search their database. There's also eSpaceNet. I don't remember the exact address, but you can find it on a search engine. But on eSpaceNet, which is from the European Patent Office, you can find all kinds of things related to patent applications. And on the WIPO site, you can find things related to the PCT applications, international patent applications. One that I prosecuted years ago and obtained a patent for was related, and you've probably seen these things. A photo machine, like you go in, you have your picture taken, but this one's different. It takes a picture. It could take a picture of two people, for example, a man and a woman, and come up with a picture of what their virtual child would look like. As you're starting out, patents are probably not on your mind. As your business grows, you will attract the attention of patent owners, and you may one day get a letter saying, we think you're infringing our patent. One thing you should do is before you go ahead and produce a new product, you should check to make sure nobody has a patent on this. So you can have a freedom to operate patent search done by a professional. There are a lot of patent searchers out there. Many of them were former patent examiners who could do a search for a reasonable price. I think you should try to patent whatever it is, whatever your idea is, especially if you're trying to seek money from investors. One of the things they look at is, do you have any patents or patent applications pending? But also, as you grow, when you do receive one of these letters saying we think you're infringing our patent, you can look at your patent portfolio, see what the company who's accusing you of infringement, see what technology they're in, see if any of your patents would cover that. And maybe you can work out a deal with them, a cross-licensing agreement, instead of having to pay money.